If you don't have counsel, someone has got to present this evidence. Now, there are administrative agencies, administrative boards, that in effect try to present the case and decide the case at the same time. I think it's a very difficult burden, and it's not one I recommend for any school board. I think someone else ought to be standing there and telling you why this is the right decision. And if you don't have counsel doing that for you, that role is going to fall with the administrator. If you don't have counsel, another question would be whether there's going to be some administrator to give the board some assistance, some advice. Different boards have different resources at their command, and someone's going to have to write a decision in most of these cases. Is your board chair going to sit down and do that, or your board clerk? If the answer is no, then you better plan far enough ahead so that if you don't have counsel there to do that for you, you have someone. And then what's the board going to do? Well, if you're a board member and it's not your responsibility to preside over the hearing, your job is ultimately to figure out what the facts are, to listen to the evidence, the testimony, and if, as sometimes is the case, there's a conflict, to decide what story you believe, and then to compare that to the rule. Someone mentioned earlier the gun cases, and sadly once in a while we do have those even here in Vermont. In a gun case, the rule's pretty clear because federal law tells us you can't have a gun on school premises. So what's your job? Your job is to determine whether or not that rule has been violated. And if there's doubt about what the rule is, your job may be to determine what the rule itself means as it's applied to this particular case. And then, if those two things have occurred, you have the guts of the decision-making process, I think, and that is to exercise your discretion and choose among the potential range of outcomes which outcome you think is appropriate given the values that your community represents and wants to apply in this sort of setting. The board chair's role is ordinarily going to be a more active one, presiding over the hearing, as we've talked about a bit, managing the meeting in terms of seeing to it, if they don't do it themselves, that these logistics are handled, functioning as a liaison between the board and council if nobody else has done it, and presumably ruling on questions of procedure and evidence if they come up. And they do come up, particularly when lawyers are participating in the game, because my colleagues at the bar and will come forward and have things to say about how you're going forward and whether it's consistent with the law that applies to the case. And somebody's got to decide those questions. And ordinarily, the way I've seen most boards handle this is to let the board chair rule on matters of procedure and evidence almost as an extension or maybe as an application of Robert's Rules of Order, which don't say really in the end that the board chair gets to decide these matters him or herself, because any ruling on procedure that a board chair might make in an ordinary context can be appealed to the rest of the board. So in the end, if I as board chair don't want to take some evidence that's presented and my colleagues outvote me, then we're going to hear that evidence.
Good point.
And as a board chair myself, my own rule of thumb, subject to all of our tolerance for seat time in these cases, if in doubt, let people have their say. The law does give the board chair and the board a great deal of flexibility here, but it doesn't mean that people get to go on forever and filibuster your hearing and leave you in a situation where you never do anything. You never get to adopt the budget because all your meetings for the next 6 weeks are taken up with this one case. And so the board chair and the board ultimately can impose reasonable limits on the testimony that's going to be taken. And I think the rule you apply here is a simple one, and that is the material that's offered new, or is it simply a repeat of what we've already heard? And if it is new, does it make any difference? If it doesn't relate to the issue you have to decide, I don't think you have to hear it.
And so the board chair should have a handy Robert's Rules with them?
Yeah, I brought my own version of it with me, and I know that the School Boards Association also has something that you use. I don't see if you could see me on screen here, but I use and recommend to boards that I work with the Modern Rules of Order, 3rd edition, and it happens to be an American Bar Association publication. And the reason I recommend it is not just because I'm a member of the American Bar Association, but because it's only 55 pages long.
Yeah.
And
we can go to the overhead camera for just a minute.
We can see it now.
We'll put it right here.
That's the publication that we're talking about.
Yeah.
And it's not the only good publication on the subject, but I think most board chairs who aren't lawyers or aren't experienced in dealing with parliamentary procedure are going to be intimidated by facing, the standard Robert's Rules, which might be 300 pages.
Yeah, or more. We actually have a simplified version that's got little numbered tabs at our office for about, $12 or $15. It's a pretty good investment. If you need to find something quickly, that enables you to be able to do that.
The statutes do say that board hearings are conducted pursuant to Robert's Rules, and I think are likely to be interpreted to allow you to choose any reasonable version of Roberts that you want to, because there are differences among the versions that are out there.
Okay. Moving on.